Ladies and gentlemen, I've got 5:30, so let's get started. Lincoln. Okay. If everyone will bow their head in a moment of silence, we'll get this meeting started. Thank you. Amen. This group's like a family. You get them together, and sometimes you have to holler to get them to settle down. And I'm glad y'all are so happy and anxious this evening. Commissioners, this is the public forum. It's an opportunity for citizens of Montreat, anyone really, to ask us questions or make a statement or whatever. And if we have a question, we'll try to answer it. If we don't have an answer right away, we will get back to you, I promise you that. So the commissioners, I need a motion to adopt the agenda for the public forum. I have a motion from Commissioner Alexander. Do I have a second?
Second.
Second from Commissioner Blake. All those in favor signify by saying aye.
Aye.
Opposed? Ayes carry. Microphone, the floor is open for public comment. Come on up, Tom. I've got some filler tonight, Tom.
Tom Friss, 98 Friss Road. I just am curious, what is the town policy about things like ice cream trucks, food trucks coming into Montreat to sell?
Savannah? Might go to Brandon.
I would say that it varies greatly depending on the context of if it's an event, something that has a special event permit, or is it something that's going to be permanent? But so yes, that's the short answer, is that it would vary greatly just depending on the context. But if you have like a specific scenario, then we could just look it up in the zoning ordinance and let you know.
But there is a process.
Yes, there would be.
If it's an ice cream truck, I have a preference and a bias. Who else? Good question, Tom. Yes, sir.
Philip Arnold, 530 McGill Drive. Do I understand that FEMA is one of the departments that is not paying their people right now? And if so, is that affecting the town and our collection of money from FEMA?
So FEMA, there are portions of FEMA that are currently furloughed, yes. So the branch of FEMA that we work with, which is public assistance, is currently shut down and has been. So it's been, I can't even remember now, probably 2 months since they've been working. During that time, we have received a reimbursement because it had already moved through all of the stages and was with the state just waiting for a check to be cut. So we have received $114,000 in that time period. So although things on the federal side are at a halt, on the state side, things are still moving. But as of right now, no end date in sight on that. And they are not allowed to take phone calls, answer emails, or schedule meetings at this time.
Are you concerned?
Yes. Just because of how much it's going to delay our progress. The sooner they get back to work, the better it is for Montreat.
Can you just explain a little better to me how FEMA works through the state, that the money doesn't come directly from the federal government?
Sure, yes. So FEMA releases lump sums of money to the state. So, and this, I can't give you specific numbers off the top of my head, but let's say they award $200 million to the state of North Carolina, for Helene recovery. And then we move through the process with FEMA. We get our projects approved through FEMA. Then FEMA kind of gives the state the thumbs up. The town of Montreat is approved for this amount of reimbursement. And then the North Carolina Department of the Treasury actually sends us the check for our reimbursement. So the funds are federal funds that are released to the state, and then we receive our funds via the state. Does that make sense?
Makes a lot of sense. Thank you.
You're welcome.
Thanks, Philip.
And
Philip has served on our finance committee for ages, and we appreciate all his input and help. Tom?
can I just do a follow-up on question? So the state is only the fiduciary, the financial fiduciary passing through. They are not making any approvals or decisions. They are just doing what FEMA tells them to do?
That's correct, yes. And the state, it can actually be helpful to us if FEMA were to deny a project or something like that. The state can actually help us appeal that. But they have no real influence other than that. They're just, as you said, just fiduciary.
Thanks.
Anyone else? Any comments, any questions? Okay, Savannah, will you and Tom bring us up to date and take questions on the new solid waste ordinance?
So I just wanted to open the floor. I know that that's probably on people's minds that we just passed our new sanitation ordinance. It goes into effect, is it October 1st? October 1st. So if anyone has any questions about what's going to be required or anything on their minds related to that ordinance, I'm happy to answer questions about that. We also have some Q&As posted to our website that you can find via a link in the Montreat Minute, but happy to answer questions.
Just out of curiosity, I had a quick question. How many properties in Montreat are in need of bear-resistant canisters or cans?
We don't have that figure. We know that there are a lot of homes in Montreat that have good functional systems that are not going to need a replacement. But we also know there are a lot of systems that don't work well that will need to either be modified or replaced. So don't have specific numbers, but we kind of have a sense of which systems need to be replaced and which worked well. If you have a question about your specific system or can, we've already done this a handful of times now, but we're happy to just come out, give it a check, and let you know this should be sufficient or this is probably going to need to be replaced.
Anybody else have a question on the ordinance? Do you have any comments to make?
No. You know me, I'm never at a lack of words. No, other than if you have any questions, we have set up a new website address or email address for any sanitation related questions, and that is trash@townofmontreat.org.
That could apply to a lot of different areas.
And we're working real hard to secure the convenience center in different ways, and those improvements will come as we move along. Anyone else? If not, I'll entertain a motion to adjourn until 6 o'clock at our regular meeting time. Have a motion from Mayor Pro Tem Fouché. Do we have a second?
Second.
Second from Commissioner Widmer. All those in favor signify by saying aye.
Aye.
Opposed? Ayes carry. We stand adjourned until 6 o'clock. Y'all can resume. Ladies and gentlemen, I have 6 o'clock. If you'll join me and stand and face the flag. Say the Pledge of Allegiance together, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Let's all bow our heads for a moment before we start the meeting. Amen. Commissioners, you have the agenda as presented, but I have one change. We have a budget adjustment to add to as item D.
Yes, it's budget, it would be budget amendment 13 and 14,
Okay, under D.
under D.
Under D. Thank you, ma'am. So with that adjustment, do I have a motion to adopt the agenda?
Mr. Mayor, I move that we adopt the agenda with changes suggested.
Commissioner Widmer made a motion. Do I have a second?
Second?
I have a second from Commissioner Alexander. Any discussion or questions? All those in favor signify by saying aye.
Aye.
Opposed? Ayes carry. My communication tonight is really rather brief in that I want everybody to please remember the Land Care Day on Saturday, and that starts at 10 o'clock and goes until 2 o'clock on Moore Field. There'll be vendors there and so forth to that have plants and so forth. There'll be information available for you if you're a gardener or want to do things around your home that would beautify it. And so be sure and attend, and we'll have a good time. It's usually a lot of fun, and it's it's like most things in Montreat. Everybody's glad to see each other, and we always have a good time. Savannah, you want to cover the consent agenda, please, ma'am, and your town manager's communication?
I will. So on our consent agenda this evening, there are the March 12th public forum meeting minutes and the regular meeting minutes of March 12th as well, along with March 13th special meeting minutes. That's the consent agenda. And then I just have a couple of quick things. The first item being that we have a new zoning administrator. Her name is Shelley Johnston. She is actually an employee of the town of Montreat. She does not work for Land of Sky Regional Council. We're really excited to have her. She'll be part-time Tuesdays, Wednesdays, and Thursdays. Our police chief search is going well. We've had a handful of interviews at this point, one or maybe two more to do. And then we plan to narrow that pool down and go into a second round of interviews. We want to really make sure we get the right person for that. A reminder about our budget workshop tomorrow morning at 9 o'clock. We're going to review Public Works budget and police as well. And then one thing I need to let everyone know is that the sign ordinance, which we originally had on the agenda and then continued, was meant to be continued to the March meeting. I thought that we had continued it to the April meeting, so I messed up there, a little goof. So what we're going to do is, and this is just for everyone's awareness, we're going to just completely drop it, re-advertise it as a brand new meeting, and plan to hold that in June. And that will also give the town council and the sign subcommittee time to get together and hold a workshop and make sure that that ordinance is really where we want it to be before it comes to the town council for consideration. And that's all I have.
Since you mentioned that, how many commissioners are going to be here for the April meeting?
For the May meeting.
This is April, isn't it? Nobody's going to be here?
I'll be here.
Okay. Two?
No.
No.
Okay. So we'll try to hold maybe I'll poll you all maybe in the morning to see if we can get a special meeting together for May, just to conduct whatever business we have and hold a public comment period, even if it's just with, even if we can just get a quorum together. I think that would be best. But I'll pull you on that in the morning.
Thank you, Commissioners. Commissioners, you have the administrative reports from the Administrative Department, Planning and Zoning, Public Works and Water, Sanitation, Streets, Finance, Police, and permitting inspections. Any questions or comments on any of those reports? Okay, we'll move on then. Floor is open for public comment.
Good evening. I am Kathy Putnam at 407 West Virginia Terrace, chairman of the Land Care Festival and Arbor Day celebration. Wanted to thank the town and council members very much for your support and help in communicating about the festival. Very importantly, my weather app says we've got 1% chance of rain that day with a high of 76. So the weather should be fantastic. We have plant sellers, produce sellers, fresh strawberries, some of our local artists who are going to be there, Treasured Tree Walk with Martha Campbell and Jason Nance at 10 a.m., and then 3 seatings of Betty Douglas's and Beth Frith's Spring Tea Party. So at 11, noon, and 1 p.m. So come with your friends and family, and we're looking forward for a great day. And thank you for your help.
Thank you for all you all have done and continue to do, Kathy.
Tanner Pickett. I'm on staff at Mountain Retreat Association, 318 Georgia Terrace. First of all, I just want to, as always, thank the staff and town council for good work that you guys do. We really appreciate that in our day-to-day work. I wanted to just mention a couple things for people to be aware of. If you're coming to the Arbor Day celebration, while you're there, if you'd make a trip up to the Huckleberry, we are doing a open house for the new retail area, the extension of the Montreat store that's in the old 10,000 Villages space, the Good Steward. We welcome you guys to come by, take a look, get a little sneak peek of what we're going to have. The grand opening will be May 23rd for that, and we'll be talking about that more, but just wanted to make sure people know that. Secondly, if you haven't noticed, every Tuesday this month we're doing some community hikes. Last fall we did spring community hikes, kind of like we do during the summer. We just tried to extend that and test it out. It was pretty well received, so we're doing that this spring. So you can find out about that on our website if you just go to the hiking page under the visit tab on our page and sign up for those in advance. So there's some good stuff, including a birding one happening later.
And you said every Tuesday?
Every Tuesday, as it happens this month, we're doing one.
At what time?
I think it's 9 o'clock is the time. But if you go on the website, it'll tell you more. And then when you sign up, Jason will send you email with specific stuff about it. So, and then lastly, just to make sure the community is aware, if you didn't make it out today or watch online for our announcement about our plans with the new lodge, we're going to be pretty soon, we'll have that recording up on our website as well as information. So just want to make sure we hit that and make sure people are aware. So, thank you very much.
Thanks, Tanner, as always. Anyone else? Yes, ma'am.
Elizabeth Dybert. I'm here representing the Presbyterian Association of Musicians, and if you have any questions about golf carts, I'm available.
Thank you. If we ever consider golf carts, you're on the committee. Okay, anyone else? Okay. We'll move on. We have no old business. Yeah, we do. Conditional zoning request, public hearing. Item A, this has been continued. I need a motion to open a public hearing.
Mayor, before we open the public hearing, if you would like, I can just review, I can do a brief overview of what we're going to be hearing tonight, and then we can move into public hearing, and we're going to give our AV guy, Josh, just a second to get things settled because something is happening.
Okay, as long as we don't forget to open
I'll just do a quick review. This is a conditional zoning request for 779 Foreman Siding Road submitted by Wade and Susie Burns. The applicant is requesting to rezone the property from R3 low density residential to R3 conditional zoning. This request is to allow modifications to dimensional standards, specifically a reduced front setback and a reduced side setback. The property is located in the town's ETJ and consists of approximately 0.26 acres. Tonight's hearing is the required legislative review by the Board of Commissioners for this application. So you will need to consider the consistency with the comprehensive plan and the public benefit. I'm just going through my notes to make sure I hit on everything. I think that that is all you need to know, other than, of course, there have been concerns raised by the adjacent property owners, which are of record, and you all are aware of those. Those are regarding a stream channel that traverses the property and stormwater flow and potential downstream impacts. So with that, we can open the public hearing, and I know both the Burns' attorney and Mr. Will Hamilton would like to speak. We have Mr. Jim Hamilton on Zoom, as well as a stormwater engineer representing the Burns family.
Okay, do I have a motion to open the public hearing?
So moved.
I have a motion from Commissioner Alexander to open the public hearing. Do we have a second?
A second.
A second from Commissioner Grant. All those in favor of the motion to open the public hearing signify by saying aye.
Aye.
Opposed? Ayes carry. I think we'll hear first from Mr. Burns, attorney.
And if I could, Mr. Helms, members of the board, thank you for letting us speak this evening. I'd like to speak. Mr. Burns would also like to speak. He just wants to give you an update of what it looks like right now. Actually, it might be better if you go first, just because you have photos taken from today. Then I'll follow him.
All right, let me say first, we've already heard a lot of things on this. So if you got something new, I hope we'll hear it. So let's not rehash all the old stuff we've already heard for hours.
With that, Mr. Helms, I am going to sit down. I do not intend to speak if the board feels you've heard enough. You've seen a lot of communication from me, but if there are questions, I stand ready to answer them for you, sir.
Thank you, sir. Appreciate you being here. Mr. Burns, I believe you're up.
We have never heard a word from our neighbor's stormwater expert. He was on a Zoom call, the only time we've had any communication, and said nothing. Mr. Hamilton gave his interpretation of what should happen, that he wants the driveway torn out and all the pipes in our stormwater basin connected and buried and all the gravel removed. And our stormwater expert can speak to that when he's on Zoom. But I would need to hear from Mr. Hamilton's stormwater expert to know what additional information you might need, a rebuttal to what they may have to say.
You want the Hamiltons to go first?
No, I'm just saying that their stormwater expert, if he has something to say about what we've done, we've never heard anything about what we've done. And Mr. Hamilton said when we did have the Zoom meeting, he hadn't asked him to look at what we'd done. He asked him if it was possible to do what Mr. Hamilton wants us to do. And so we're not sure how to respond to that. But
And if you would, be sure to explain the photo that you've handed out to the board members when you get a chance.
okay. But the photo you have is of the amount of stream, the 26 feet that's open on our property. And it's a 4-foot pipe goes into a channel, and then a 3-foot pipe comes out, then a 16-inch pipe comes out. And then what you can see is the asphalt and the concrete under our screen porch. And that basin is, in hindsight, incredibly fortunately designed. You've got a 4-foot pipe that was there and a 3-foot pipe that was there where it comes in and 3-foot goes out. By us adding the smallest 16-inch pipe, and then by putting in the concrete bulkhead that we did and the big boulder at the bottom of our paved driveway. If we ever have another Helene, instead of, as Mr. Hamilton at one time suggested, that we connect a 4-foot pipe, tear it out 3 foot and put a 4-foot pipe in and connect all that, pipe it all together. If we ever had another Helene and you had all of that water, instead of going through 20 and 26 foot short term, if you had it going through 50-some feet of water, with all of the power from Helene, you would have a 4-foot diameter fire hose nozzle aimed at the bank of Mr. Hamilton's stream. The way it's designed, that basin allows to tap the brakes on the force of the water. Part of it goes to the 3-foot pipe, part goes to 16, and if it overpowered at all, it goes right down our driveway, and fortunately it's paved, so there's no gravel to wash in, and it would just work as it did in Helene and prevent harm from that. And just as the smallest thing, Dr. Fouché taught math in college, and we had a lot of engineering, and the math professor would say on really complex problems, it took you 5 minutes to figure out. If you're on a test, before you turn your paper in, read the question and see if the answer was reasonable. And tonight, we got from the town a variance for a 2-foot chimney on the side and a few feet variance on the front porch. And our neighbor complained that the town should have interpreted the ordinance differently and put a 30-foot setback beside the stream. And then he argued that that should have been a condition of the zoning approvals for the chimney and so forth. If you put the 30-foot setback on the stream and the 80-foot setback we had to have for the septic, then as a condition of approving the chimney, you not have permission to build anything on the entire lot. So it's just an indefensible piece of math, what they've been requesting, and I hope a reason will prevail. And I hope that everybody's got all the information they need. We would like to respond if there's some things that come up.
And I did misspeak. I have one additional thing, Mr. Mayor, members of the board. May I wait? Yes, sir. So one additional thing, if the board is so inclined to grant the conditional zoning, we would ask that one of the conditions that Mr. Hamilton had requested, that pipes be moved so that they're not directed toward his property, that be added as a permissive condition. So we'd ask there be a condition that says we may move those pipes because we fully intend to do so, but we'd like to be able to do it with just a zoning permit. So if the board is moving in that direction, you have any questions about that condition, I'm happy to walk you through what we're thinking. Thank you, Mr. Mayor. Thank you, members of the board.
Anything else?
As I said, I do have more to say, but I'm going to hold it at your request, sir.
Mr. Hamilton? Will, you going to speak tonight?
Yes, sir. Ms. Parrish, thank you. Mr. Mayor, council members, my name is Will Hamilton. As you know, I'm Jim and Christina Hamilton's son. I'm here with my sister, Catherine, this evening. And thank you for the opportunity to address the council and talk about our continued opposition to Mr. Burns' conditional zoning request. To briefly recap, at the January 9 meeting, we proposed a compromise that would allow Mr. Burns to keep his house. It would protect the environment, and it would resolve the legal issues. And I showed the town council the following site plan. Ms. Parrish, we could put that up on the screen, please. Thank you. I showed the town council the following picture of Mr. Burns' site plan. The shaded areas represent built-upon areas. The red shaded area is Mr. Burns' roof. The area with the dashed gray lines is the gravel driveway, and then the black area is the paved driveway. and most of the polluted stormwater from those shaded areas is collected and intentionally diverted onto our property by Mr. Burns' stormwater management measures. The 3 arrows show where the stormwater is released onto our property, which harms the environment and is an illegal trespass. I know Mr. Morphus just said they were considering making some adjustments, and we can address those more in a second. During our settlement discussion, Mr. Burns offered to pipe and release the stormwater from his roof to the back of his property. Next slide, please. But Mr. Burns refused to remove the other 2 trespasses. When we declined to accept that settlement offer, he threatened to block our access to our house. Next slide, please. Here is a survey that Mr. Burns' lawyer, Mr. Morphus, sent to us showing us how Mr. Burns intends to block access to our house. This is a survey of William Wade's and Francis Crozier's, I believe I'm pronouncing that properly. Their house is located where Graybeard Trail becomes a gravel road and enters the ETJ, and the black bolded line represents their property line. Next slide, please. The red dashed area, the red line is Graybeard Trail, and you can see that it intersects with the Wade's and Crozier's property. Next slide, please. And that circle there is where Mr. Burns is threatening to cut off our access to our house. He basically says we don't have an easement to get up there. And when we declined to accept that offer, which would have allowed them to continue to trespass, as I said, they threatened to cut off our access. And I want to make very clear, I have no idea if Mr. Burns has even told Mr. Wade or Mr. Crozier about his plan, so I don't want to sound like I am implicating them. But this is a threat we received from Mr. Burns through his lawyer, both verbally and in writing later in their settlement offer. And Ms. Parrish, you indicated that there might be some further questions to clarify when we spoke the other day, so I'm happy to answer any of those the council might have right now.
Any questions, commissioners?
Will, if that property is owned by the Wades and the Croziers, how does Mr. Burns have the authority to cut off access?
I am not entirely sure, and Mr. Morphus, I have the transcript of our call, indicated that he is not entirely sure how it would work, but they think they could do it, and that's where they left it.
Mr. Whitney, if I may respond. So, as you know, there's been a lot of talk back and forth. As we've said, Mr. Hamilton said he'll keep this in court for years. He said, well, we'll let you move your house plans 30 feet, and then we won't fight that. He's proposed stormwater project improvements that would create more runoff with more velocity, not less, and he won't settle otherwise. So we pointed out that if they're going to continue to be unreasonable, they should be aware that they do not have lawful access to their property. Both the town and the Burnses have obtained easements from Wade and Crozier. Our point was simply that they have never obtained an easement. We have not contacted Wade and Crozier. We have no desire to bring them into this. We have not threatened to sue Mr. Hamilton. We have told them that if they're going to be acting in this heavy-handed way, they should be aware that they don't have lawful access to their property. That's all we said.
Dad is available on Zoom to address any legal questions related to that y'all might have. We continue to oppose Mr. Burns' conditional zoning request because we were unable to reach a settlement that protects the environment and resolves the legal issues. In terms of the environment, next slide, please. There was 26 feet of stream on Mr. Burns' property represented by the blue area, and he has encircled that area on all sides with built-upon areas, his house, and a gravel and paved driveway. And this is a violation of the Montreat Stormwater Ordinance's 30-foot setback requirement in Section 305.1, which the Superior Court in our Board of Adjustment case found applies here. Now, Mr. Burns is essentially seeking a variance through his conditional zoning request, and his argument is that the stormwater measures he has installed have prevented washout and protected his house, including during extreme weather events like Hurricane Helene, and his expert, Mr. McLean, has reached the same conclusion. We do not dispute that conclusion. However, while his measures have prevented washout, they do not keep polluted stormwater from his built-upon areas out of the stream or Flat Creek, which is one of the core goals of 305-1. Next slide, please. For example, the porch roof drains polluted stormwater directly into the stream. We submitted a video showing that to the Zoning Commission, and when they asked Mr. Burns about it during their October 23, 2025 meeting, Mr. Burns acknowledged that the porch roof was intentionally designed to drain straight into the stream. The rest of the stream is encircled by gravel and paved driveways, as you can see. Mr. Burns has installed curbing to keep polluted stormwater from those built-upon areas from entering his part of the stream. However, the curbing is designed to divert and channel that stormwater down his paved driveway so that it empties into our part of the stream through a gap at the bottom of the driveway. Next slide, please. Mr. Burns has also installed 2 drains above his properties. The big one collects polluted stormwater from gravel driveways, a gravel driveway that is not on either one of our properties, and then the red circle, the second drain, is a little bit harder to see. Next slide, please. But you can see them on the site plan at the top, that big red bar, and then the smaller red circle below it, and then that dashed line is a pipe connecting the drains that then empties onto our property. Now, I know Mr. Morphus suggested they might be willing to change where that empties out into, and we'd be interested to hear that proposal. But at the moment, Mr. Burns' stormwater measures have not met the goal of 305-1 to keep polluted stormwater out of the stream. They simply change where the stormwater enters the stream. Represented, if we zoom out on the image a little bit, please, there are 3 red arrows that show where his stormwater management measures release polluted stormwater onto our property. So the first part of our proposal compromise that we made in January was for Mr. Burns to pipe and cover the 26 feet of stream on his property, which would prevent polluted stormwater from entering his stream and remove the 305 violation for this part of the stream. And Mr. Burns has repeatedly said this solution was not feasible, but our civil engineer, Wyatt Edsel, who is here tonight, believes that it is. And Mr. Edsel graduated from NC State with a degree in civil engineering and has over 12 years of experience designing and overseeing development projects in the area. So, Mr. Edsel, if you wouldn't mind coming up. Thank you, sir.
Will, do you have a picture that you could show us where you're talking about? Where you're talking about covering up?
If we go back a couple slides, please, to the picture of the house. One more. Thank you. So you can see the curbing around the curbing behind that is the stream in question. Right there, Dead, exactly, right there.
What are you talking about covering up?
Covering up the stream with a pipe, and then burying it so that polluted stormwater would not enter the stream. And then because the the stream has been covered, it is that particular section of the stream is no longer a violation of 305-1.
I'm Wyatt Edsel with Edsel Engineering. Appreciate the opportunity to address you guys. The Hamiltons had asked me to look into the feasibility of connecting the culvert systems, the area in question there, and it's my opinion that it would be feasible to connect those systems if the connection points where any pipe change in horizontal or vertical direction is done in a junction box, and adequate pipe capacity is provided on the downstream side. Do you guys have questions for me?
Any questions?
Does the existing downstream side have sufficient capacity now?
I have not done a hydraulic analysis of the capacity, but the upstream culvert is a 48-inch diameter pipe, and the downstream pipe is a 36-inch pipe and a 16-inch elevated culvert. So there is somewhat of a constriction as it goes into the lower pipe.
And you haven't done any calculation?
I have not done hydraulic analysis, no.
Just a second, let me see if the commissioners have any other questions.
Edsel, could you explain how covering that would mitigate that situation? Because you're still taking a larger volume of water and trying to put it through a smaller pipe. You're just covering it with and putting another pipe in. I don't understand.
Sure. I think the intention in covering the pipe is to prevent water from impervious surfaces from running directly into the stream. The intention of the Montreat Stormwater Ordinance is to allow water that runs off impervious surfaces to go through a 30-foot vegetated buffer before entering the stream. And by culverting that section of stream, the runoff from impervious surfaces would not be allowed to flow directly into the stream.
If I might briefly add, we do not oppose enlarging the size of the pipe on our property to make the system work.
I do have a few questions. This is highly irregular. He's not even qualified as a stormwater. I think the board should be aware of that.
Will.
Should I continue?
Sure.
All right. Thank you, Mr. Edsel. Appreciate it. Excuse me. So the second part of our compromise proposal would be for Mr. Burns to remove impervious surfaces, specifically the gravel and paved driveways within 30 feet of either his or our stream as impervious surfaces or a violation of 305.1, and doing so would significantly reduce the amount of polluted stormwater entering the stream and then later Flat Creek. In terms of the legal issues, I am not a lawyer. Dad has submitted a number of memoranda summarizing the legal issues. There's the September 8th, 2025 memoranda, which I believe is in the agenda packet. There's one from January 5, 26, which I believe, Ms. Parrish, you have and passed on to the town council. He's also available on Zoom to answer any specific legal questions. But the North Carolina Court of Appeals recognized in New Bern LLC versus First Berkshire Properties that it is unlawful for one private party to intentionally and unreasonably divert and deposit stormwater onto another private party's property. And that is exactly what Mr. Burns is doing with his stormwater measures. Every shaded-in area I showed earlier on his site plan is a built-upon area where the polluted stormwater has intentionally been diverted onto our property. And respectfully, the town council lacks the legal authority to authorize a perpetual trespass through conditional zoning. That would be ultra vires and in excess of the council's statutory authority. A second legal issue is that a court might decide that approval of Mr. Burns's conditional zoning request is illegal spot zoning because it only benefits the property owner, it harms a neighbor, and it harms the community. Conditional zoning would only benefit Mr. Burns because other neighbors would be subject, other neighbors near the stream would be subject to the 30-foot setback and 305.1. It's clear from the site plan, if we could put that back on the board, please, that his construction has harmed us. He's essentially treating our property like a storm drain for polluted stormwater. And it also harms the community because that polluted water eventually ends up in Flat Creek. Further, it would harm the community to set a precedent that a property owner can avoid the BOA's very strict procedures for variances by seeking conditional zoning, and approving the paved driveway in particular, which was built in flagrant violation of the Superior Court's finding that the 30-foot setback applied here and was built without a valid permit. It would not be in the public interest to condone illegal conduct. Mr. Burns' site plan is also not consistent with the actual construction now that he has paved his driveway. If we could go several slides forward, please, to the picture of the gravel driveway. Several more, please. There we go. Thank you. This is a picture of Mr. Burns' gravel driveway when he submitted and received approval to advance his conditional zoning request to the Zoning Commission. And you'll notice that there is no curbing at the back right of the driveway. Next slide, please. Here is the paved driveway, and you can see there is now curbing at the back to channel water into the gap at the very back onto our property. Next slide, please. You can see that's a close-up of the gap there. Next slide, please. Further, this is the site plan that Mr. Burns submitted to the Zoning Commission, and the site plan represents that his driveway is canted away from the neighbors. The literal text up there says, and it's circled in red, "Cant to divert SW from neighbor." However, when it rained on Easter, the water flowed straight towards the gap on our property. If we could play the video on the next slide, please. I also have would you like to see the video on my phone? Okay, you have to take my word for it. So what the site plan represents in terms of stormwater management and what was represented to the Zoning Commission when they voted to advance the conditional zoning request and how his stormwater management system actually functions today are the exact opposite. So for all of these reasons, we think it is likely that approval of Mr. Burns' conditional zoning request would be deemed as illegal spot zoning by a court. I said this in January, and I'll say this again in closing. We do not want any more litigation, especially not with the town. But we do want to be treated fairly, and that desire has been reinforced by Mr. Burns' threat. So there are two options we think would be appropriate. Option one would be to approve conditional zoning with our compromise proposal conditions attached, that the stream on Mr. Burns' property be piped and covered, and that he remove impervious surfaces within 30 feet of the stream. That would allow Mr. Burns to keep his house, protect the environment, and resolve the legal issues. And if Mr. Burns doesn't like these conditions, if he thinks piping the stream is not feasible, he can simply decline the conditional zoning approval and continue with his appeal of the BOA case. Option two would be to simply reject Mr. Burns' conditional zoning request and let the BOA decide this matter, which we think is the appropriate venue in the first place. Either one of these would be acceptable outcomes on our end, but to approve Mr. Burns' request as is, that would be approving harm to the environment, approving unlawful conduct, and in the light of Mr. Burns' threat to cut off access to our house, it would be condoning conduct that does not represent Montreat values. With that, I want to thank the Town Council for the opportunity to present our case, and Dad and I can answer any questions you might have.
Will, do you have anyone else to speak?
Unless you have questions for my old man, I do not.
Questions, anyone?
I have two questions, one for you and then one jointly for the two of you. Number one, Will, do I infer that you are, or the Hamilton family, is questioning the conditional zoning ordinance? You're suggesting that it might be spot zoning instead of conditional zoning? Because that brings up something much bigger and different.
So I think Dad can jump in if I misrepresent this, but if conditional zoning is approved, Mr. Burns' request, we believe a court would consider that to be illegal spot zoning for the reasons I laid out, because it would be condoning a trespass, among other issues.
So I'd like to respond to that. And I'll point out by noting that neither Will or James Hamilton are licensed lawyers in North Carolina. I am, and I've litigated spot zoning cases. I tried to save this board some time by not going into my 10-slide PowerPoint presentation, but I feel that may be necessary at this point. One of my slides specifically addresses spot zoning. Case I litigated several years ago, UCV Town of Shallotte, and we raised this issue about how many people do you have to have as owners for there to be unlawful spot zoning. What the North Carolina Court of Appeals held, quoting Covington v. Town of Apex in UCV Shallotte, was an essential element of spot zoning is a small tract of land owned by a single person. This property is owned by Wade and Susie Burns. I raise this issue because there are other cases in North Carolina where it's owned by two people who kind of function as a unit, and the Court of Appeals rejected that. So under North Carolina black letter law, this cannot be spot zoning. Ms. Parrish, could you please go forward, let's say to slide 8. I also want to address this issue about trespass, also presented by people without law licenses in North Carolina. What they have quoted you in one of their letters is it says, Mr. Hamilton has written that the town lacks legal authority to approve a conditional zoning ordinance that authorizes an unlawful trespass by a private party. To do so would be to act ultra vires and in excess of statutory authority. That is simply not North Carolina law. North Carolina law is clear that each possessor is legally privileged to make a reasonable use of his land, even though the flow of surface water is altered thereby and causes some harm to others. The liability is incurred when his harmful interference with the flow of surface waters is unreasonable and causes substantial damage. Short answer is if there's trespass, that's for a jury to decide, not for this board in a conditional zoning procedure. I believe you have a second question.
I did, and I addressed this to Will and to Wade. At the January meeting, after quite a bit of conversation, both parties agreed to take it out of the lawyer's hands and put it into the experts, the land experts. And you agreed that you'd get Edsel, and Wade agreed to get someone, and they would talk to each other and come up with a compromise. It doesn't sound to me as if either one of you did that or it didn't happen somehow. And Mr. Morphus, let them speak, please. What happened there after that agreement in January that we all agreed to? Why didn't it happen?
We got on a call and we were unable to reach a compromise.
When you say we, you mean Edsel and his counterpart?
We were both Mr. McLean and Mr. Edsel were on the call, and the nature of the call, neither expert spoke. We didn't get to that point, I think is the safest way to describe it.
If I may, I can tell you why. Mr. Hamilton, and I appreciate Will saying this because it made it pretty clear, hired Mr. Edsel for one reason, and that was to validate his proposal. He did not hire him to seek compromise. We, like you, hoped that two stormwater engineers would put their heads together and they would say, here's something we can do. That was not what Mr. Edsel was hired for.
Compromise is not to allow a continued trespass. So that is why we weren't able to even get to the part where the two experts talked, because we said, hey, thank you for offering to pipe, change where you're piping the roof, but there's these other trespasses that we would like addressed. And they said something to the effect, I have the transcript, the driveway is not coming up, that's not going to happen, something like that. So we didn't get to the opportunity to have our experts speak because.
Will, can I be heard?
Yeah, we got you, Dad. I think Dad would like to address the spot zoning issue.
The agreement was not to let the experts, the engineers, decide the matter. I specifically said that any decision of the compromise would be left to us, not to the engineers. The engineers have given their advice. Mr. Edsel has given us his advice as to what is feasible in terms of piping. And we think since piping is feasible, that's what should be done. While I'm speaking, let me mention just a couple of other things. Mr. Morphus says that in this situation, spot zoning doesn't apply because it's not a single home. We cited in the brief that we put in, the memo we put in on September of last year, a case called the Alderman case that specifically holds that a husband and wife constitutes a single person. And Mr. Morphus has just cited a music case that he was involved in. That case, if you read it, confirms the holding in the Alderman case. So a husband and wife in North Carolina law count as a single person, which means that this is spot zoning, and the question would be, is it illegal spot zoning? And we've cited a number of reasons in our memorandum why it would be illegal spot zoning.
Anything else, sir? Mr. Hamilton, do you have anything else?
I'm happy to answer any questions the town council may have about these issues.
Anybody have any?
I do have one other point. In terms of what is trespass, in terms of diverting water, it is correct that the diversion has to be unreasonable. And we think, and it's demonstrated by the graphs that William has put up on the screen, that the diversion here is quite unreasonable. It is unreasonable, for example, to put in an asphalt driveway that channels stormwater down that driveway into our portion of the creek. I'd be more than happy to litigate that issue under the issue of reasonableness.
Anything else, Mr. Hamilton?
That's all I have, unless you have some questions.
Does anyone have any questions for Mr. Hamilton?
I just want to make sure I understand it correctly, that your compromise would be to connect the pipes, and what would that entail to connect those pipes?
It would be to cover the 26 feet of stream on Mr. Burns's property and connect. The whole thing would be a pipe. The particulars of that, my expert, Mr. Edsel, could speak to. But
And I'd like to give him the opportunity. Could you pull up my PowerPoint presentation for a time? And let's see, I think it's probably the 6th slide.
We're getting that pulled back up. 1 second.
Sure, no worries. All right, very good. Mr. Edsel, could you come up here, please? And, I mean, you can ask him questions, but we're going to let him talk about this right now. So let's start with some level setting. Because Mr. Hamilton keeps saying stream, sorry. Mr. Hamilton keeps saying stream, stream, stream. Is this an ephemeral stream, an intermittent stream, or a perennial stream? Mr. Edsel, do you know? Come on up, sir.
North Carolina law, or the site has already, everybody knows it's an ephemeral stream. That's
Okay. So what's the difference between an ephemeral stream and a perennial stream? Can someone tell me?
It's a classification of stream.
Okay. So does an ephemeral stream have water running in it at all times of the year?
No.
Okay. So what we have here that has been called a stream is an ephemeral stream, correct? Is that right?
I haven't seen.
That's what the state of North Carolina called it.
Okay. So you don't know if it's an ephemeral stream or not. Is that what I'm hearing?
I have not received a jurisdictional determination stating its classification.
You know there's one in this case, right?
I haven't reviewed the case stuff.
Okay. So let's just talk about what you can see on the photo. Do you see those boulders there?
Yes.
In stormwater engineering, what do we call those?
Let's not turn this into you.
Here's the question.
He's not on the witness stand. This is not a court. Just hold on a second. I'm going to let you speak. You're not going to treat someone like that in this room, okay?
I apologize.
Sit down, young man, if you would like to.
And here's my simple question. I do apologize. It's outrageous because they talk about, is it feasible? The question is, what works? And that riprap, those boulders, dissipate energy. So water comes out and it dissipates energy. If you have a single pipe, it makes it go faster. Even if you adjust it so that the pipe is no longer 3 feet at the end and 4 feet at the beginning, it will not work as well. And there's no engineer here who can say that that works better than what's currently there. And I apologize, Mr. Helms, I was out of line, but that's the point I was trying to make. Thank you.
Understand.
I think that's a good example of why we had difficulty reaching a compromise.
So, Will, it's covering, I don't want to bring this back up, but it's covering and removing the pavement is
Impervious
no
surfaces.
compromise.
Yeah, the gravel and the paved driveways.
So, Will, does that include the gravel driveway in front of the house, the parking area?
It includes anything within 30 feet of a stream, but if he covered the section of the stream on his property, then, you know, it should be, if it's not within 30 feet, it should be okay.
And we would ask, if this is the direction the board's going, should drains that have been put in elsewhere on the property, who help drain from the Burris property and from the town's own well site, should those be taken out? Should there be other adjustments? And I would just say, with all due respect, they're proposing things that have no engineering calculations to support them. So we just strenuously object to conditions being arbitrarily placed. We're happy to compromise and go with condition number 2, which is that we move pipes. But the others need to have some kind of engineering calculation to support them.
Thank you, sir. Will, do you have anything else?
No, sir.
Okay. Does Burnside have anything else?
Just wanted to point out, when you see that slide there of the site plan and the large drain we put in and the small one, both of those we put in because we have a lot of stormwater that comes from your well sites down on that property. And I put that catch basin in to prevent it from flowing onto the Hamilton property where they just did a landscaping and a whole lot of trees as a visual screen, and captured stormwater not from us, but from northern property, which is Town and Burris. And we pipe that under our own property to empty it into the stream where it caused no harm. And the pavement was very important. That was everything I gave you earlier was 16 things we did. That was the 17th thing, because that section of driveway was gravel. So when we have a heavy rain, gravel was going to wash down into that stream. The water that's washing it down into that stream is from other properties. So we were merely managing stormwater so there wouldn't be any impact on them. And when he points out that there's one section between two gables of our porch roof that will allow that water to go straight into the stream. It was misrepresenting to say it was much more than that. And they played that for the Board of Adjustment. And one of the members said, it's just a trickle. And so it's like a kitchen spigot on its lowest setting is what comes out of there in the rain. The rest of it all goes in those tanks, 3,000 gallons. All that's slow release at 1 gallon per minute over 3.5 days to protect it. The way we did everything, stormwater came from all 3 sides of that property into that stream. When we built a house, nothing from the left was coming in. When we put all these other drains, nothing from the north was coming in and washing out their new garden area. And it was a powerful thing to be there that night and to watch all that, and felt a whole lot maybe luckier than smart than what I did work so well in Alene. And I think this is a misrepresentation of what's actually happened. Thank you.
Wait, could I ask a question? You mentioned a condition regarding the driveway. Is that one of the 16 conditions that are in your application that you're mentioning?
I don't remember.
Because I don't see it in there. That a driveway was a part of this is what you refer to as basically the risk prevention measures you took,
Right.
which look very comprehensive. I just heard you mention the driveway was part of that, and I read through it, and maybe I missed it. But.
Well, what I should have said is the 17th thing I did was the
17th thing, but it's not, there's only 16 here.
Right. The 17th is when I finally got a paver to come in and pave.
That was part of our.
Susie, step to the microphone. All this is being recorded, you know.
Thank you. I think you're referencing whenever we did pave the driveway. The driveway had been something from the get-go, and it was prior to even Hurricane Helene, it was okayed by the town.
It was okay by the town because it was permitted under the prior zoning.
Right, which respectfully, we did, respectfully, last time, we realized that was not part of the other. So respectfully, we had said that the last time from our attorneys.
But I just want to make it, you do list 16 conditions, and I congratulate you on it, Wade, of the various items that in your application you said you did to prevent that force, and I congratulate you on it. But there is no number 17, and there was nothing about that driveway in your application.
Because the driveway was...
The way I read it.
Right, the driveway wasn't part of the stormwater management. Driveway was how you get to the garage. Everybody has a driveway.
This is a zoning application, not a stormwater management application. Did you get your stormwater management permit from the town or from the county?
Town,
Town, okay.
right,
So the town has stormwater management jurisdiction.
correct. Yes.
Anything else from the Burns side? The Hamilton side?
I think the last thing I would say is we are not trying to tear down Mr. Burns's house. We just don't think it's fair for his stormwater management system to essentially treat our property like a storm drain.
Thank you, Mr. Hamilton.
Mayor, may I make one more comment?
Yes, sir. If you would address us first and ask permission, that would help, instead of just blurting out, okay?
Uh-oh, we can't hear him.
The permit that they had for that driveway was not valid after the Superior Court ruling. There's a North Carolina statute that says that if we want an appeal, as we did, then all development approvals are no longer in effect. So when they put that driveway in, they did so without a valid permit. And that is spelled out in one of the memos that we have provided to you. Thank you.
Thank you, Mr. Hamilton.
I always say that to Mr. Mayor, that he's not licensed in North Carolina, and that's not what the judge's order says, and it's not accurate. I'm happy to go into any detail the board wants on that.
Thank you, sir. Anything else from either side? Comments from the public? You got a chance to weigh in. Okay. I need a motion to close the public hearing. We're going to talk about it as soon as we get going.
One second, Mayor. Should they leave it open for their discussion, or should they go ahead and close it?
Leaving it open is that if you have questions that develop as you're discussing it, you can call up people to answer those questions.
I want the people to understand that we'll call you up if we have a question. You're not going to jump up and run to the microphone, okay? I don't want this thing to get chaotic, okay?
And I think setting that rule is within your authority as well, Mr.
Okay.
Mayor.
All right, commissioners, let's hear from you.
Well, let me start out by getting away from the contentious stuff to, let me just, I've told the commissioners, I'll tell the members of the public here, I was involved in the preparation of the conditional zoning ordinance. I was on a committee that was formed from the Planning and Zoning Commission. Planning and Zoning Commission to redo the entire zoning ordinance. And as we went through that process, we decided that it would be helpful to include an ordinance on provisions on conditional zoning as part of the new zoning ordinance. So it's new conditional ordinances are new for Montreat, and actually they were intended to be an alternative to variances, because variances, as Mr. Hamilton said, can be extremely hard to get. And in a town like Montreat, when you don't have uniform lot sizes, in fact, we have the polar opposite. There are two lots that are the same. Sometimes a variance just doesn't work for the public good. And so conditional zoning is an alternative that we felt was appropriate, and it became part of the, and actually representative of the Land and Sky Regional Planning Council, and I drafted the initial version of it, which that then was referred to the committee, and the committee made a few changes. It had to, because there were other lawyers on it, and approved it. So I'm familiar with the ordinance. And to get away from the controversial stuff, but to do what lawyers always do, is make things very complicated, but every I dotted and every T crossed. Let me say that an important part of any conditional, or at least our under our version of a conditional ordinance, an important part is an exhibit map / schematic drawing and supporting text. What you need to understand is conditional zoning is an overlay zoning. When this proposal is for a conditional zoning under R3, and what the zoning is basically a set of papers that include a map, and they also include a written supplement, and that written supplement is intended to include various conditions that the zoning is granted on. And those conditions, if acceptable to the applicant, then they get the zoning. If the applicant doesn't want to accept the conditions, the applicant doesn't have to. He's not forced to, or she's not forced to. So part of my problem is in the whole milieu of the way this has come about. Actually, this, and by the way, under our ordinance, this document, this map with written attachments, is actually recorded, is certified by the town clerk to be what the board approved, because that's the ordinance, okay? And then that's recorded in the public records of the county, okay? And then a copy of that is returned to the town clerk to file with the zoning records, so that when anybody comes in to check what the zoning of that property is, it's very clear. Any buyer of the property is put on public notice that all these restrictions or conditions are there. It's just the way it works to make this whole system function. But in the whole process of this, we've never been presented with an exhibit map / schematic plan or any supplemental written conditions, supplemental writings that contain any conditions. And so there's actually nothing for us to vote on. All we've got is an application that references some possible conditions, but doesn't give us any conditions. And so there is a map that is attached as an exhibit to the application. And so we've got a map of sorts, but it's also, that map doesn't comply with all the requirements in the zoning code for what needs to be on the map, including simple stuff, okay? I'm not talking simple stuff like a north arrow, like a date, like the acreage. Probably shouldn't have even accepted the application, but they did. All I'm saying is, getting down to the nits, which is what you got with a lawyer sitting up here, that we need to put an ordinance in order for this commission to vote on. And I'm going to suggest that it does require some conditions. In a normal circumstance, we're doing this backwards. In a normal circumstance, Wade Burns would come to us and he'd say, I want to build this and I want these setbacks and here's what I want. And he said, if you'll give me that, I'll build the system with A, B, C, D, E, F, G, H, I, J, K, L, M, N, O, P, okay? And what's happened now, this is backwards. He's coming to us after it's built, and to get us to agree to it, he said, I've done A, B, C, D, E, F, G, L, M, N, O, P, okay? The difference is, unless we put A, B, C, D, E, F, G, L, M, N, O, P in an ordinance, it's conditions for that ordinance. It's not binding on the property in perpetuity, which was intended by the ordinance. And so we need a document that lists, and it's housekeeping, okay? But it's important housekeeping because it makes the system work. Then we've got the actual zoning ordinance that will be certified by the clerk, recorded in the public records, and all the conditions that everybody's relying upon if we insist on whatever conditions we insist upon are there. So I'm going to suggest that we have our staff prepare an ordinance with the map, schematic map and plan, and we've got 16 things, and it's why I knew right away that there was no 17, because I've been looking at these 16 and admiring what a good job you did in identifying all the various things that would deal with that water, at least in the water quantity. I don't know anything about, we're not talking about water quality here, we're talking about water quantity. And I admired them. And then there was also 6 major design elements, which you also identified, and you identified it in the application that they were critical. That's your word, critical. And and risk aversion techniques, these 16 are what you, and so I assume there's no problem with us putting all these things, which Wade's already built. But they just make sure that if it's already built, then it'll stay there. And what we also need to have assurance of is these requirements or these stormwater improvements are maintained, repaired, and replaced by someone, because otherwise the system doesn't work. And I don't know, our stormwater ordinance, you said it was issued under our stormwater ordinance. Our stormwater ordinance requires an agreement for the maintenance of stormwater system. I don't know that we've got one. Sometimes we don't get those. It's recorded. Okay, we need to take a look at that, but if that's there, then that's fine. So we've got, and that's sort of a loose end. We just need to make sure it's there before we pass an ordinance. There's a couple other loose ends that, again, I don't think are problems that are, at least me looking at it critically, and you're going to have to apologize. I'm a lawyer. That's what they trained us to do. But there are a few things, again, these are loose ends. I don't think they're problematic except that they have to be addressed. One, a significant portion of the system or a portion of the system are a series of broad swales located on an adjacent lot. That adjacent lot is not a part of this permit. And I don't know, and I understand that another person owns that adjacent lot now. I don't know what provision has been made for the retention of those swales on those adjacent lots. My guess is, given the size of the lots over there, those swales, that there's no easement for those swales. And so I think we need some sort of condition which says that if those swales go away, there's some sort of mitigation to deal with the drainage that would be taken away by those swales. And it may not be much. It may be just a minor thing. I'm not trying to create issues here. I'm trying to make sure all the I's are dotted and the T's are crossed. Okay? The other thing, and again, I'm just sorry, but there are a number of parts of the system that are not located on Mr. Burns' property. There are a bunch of improvements that are in the right-of-way, and that's fine. I just want to make sure that we have assurances. I don't know who owns that right-of-way. If it was platted in Buncombe County has a right-of-way. We just need to make sure before we pass the ordinance that whoever needed to get permission for those improvements, we got permission for the improvements, that we have a fully functioning system here and the legal right for it. And I'm sure Wade probably took care of all that. Just dotting I's and crossing T's, okay? And we need to make sure that there are some provisions somewhere. If it wasn't on his property, we need to make sure whatever agreement we got with Wade is also going to cover the maintenance, repair, and replacement of those improvements too. Or we figure out some other way to do it. Because if we don't have that maintenance out there, well, first the system may fail. We've just created a problem. It just was waiting, it's waiting to happen. And we're probably in violation of our permit with the federal government, Clean Water Act permit, which requires us to provide for maintenance, repair, and replacement of any private systems. So it's just something we got to do. So those are what I would call loose ends that need to be taken care of in a set of conditions. And then just sort of cleanup matters. So I don't think that's a problem, but we got to have something to vote on. And right now, we don't have anything to vote on that Angie can certify we approved and her take down to the courthouse and record. It's just not here. Now, There are two things that aren't as easy as that. That should be easy. It's just time and getting it done, I think. And so now I'll take my lawyer hat off and be just more of a commissioner. I've got a real concern that if we approve this plan the way it is now, I know what our ordinance says. It says you can only build improvements that are set forth in that document we record. And the only thing that's been submitted to us for approval, and the only thing that's been submitted to the Planning and Zoning Commission approval, shows no improvements there. Driveways are improvements within the meaning of that in our code, okay? Now, driveways are not improvements for certain purposes, for like setbacks, because driveways normally go out. But with the exception of limited exceptions, they're improvements, and they're not on this plan. And so what it means is that if we approve this tonight, with this plan, whether it's tonight or any place, it's going to be automatically in violation of the ordinance we're passing. And I am concerned that is just automatically going to create grounds for a lawsuit against us because the physical condition of the property is not consistent with what we're approving. Now, we might go back to the conditions that we're talking about and put a condition in our plan, in that written summary as a condition that the driveway be removed within 30 days or 60 days or whatever. That would ensure that the property would comply with the ordinance we're passing. It might take 60 days to get it into compliance, but it would ensure that. The final thing that is a concern to me is that I want to make it clear, I guess, that and maybe, and I need your help, Brandon, with this, but the lawsuit between these two parties regarding the variance, rather the setback required from the stream. I don't see how, I want to make it clear that in my perspective, and if this needs to be a condition of our approval, it needs to be, that nobody can rely on this as solving that issue. We can't, in my opinion, and you correct me, and I'm dead wrong all the time, just ask my dear wife. I don't see how we can give a variance for a stormwater buffer requirement by virtue of a conditional zoning approval. I think that has to come through either impliedly or expressly. I think whatever that issue is about that 30 feet is still got to be resolved by the courts. I don't think the fact that we have conditional zoning can supersede it. That we do now have an actual, I think it's section 319, an actual section in the general code which provides for a variance to the setback requirements for the stream buffer, okay? But I don't think we can do that by virtue of conditional zoning. And I want to make it clear that I'm not prepared. I'd like an answer to that question. And I'd like to make it very clear to everybody that it's not, wouldn't be my intention to solve this lawsuit by virtue of this permit. And in fact, from the way I'm thinking, and I may be thinking wrong again, if they still lose this lawsuit, they got to come back and change this ordinance back so that in fact the ordinance complies with the stormwater. They'll have to come back and modify the plan. So you know, if we were to put some, so I'm just, you know, I just want to make sure everybody understands this is complicated. It's not easy. It ain't going to get done tonight if we do it right. And there's no reason to do this wrong. I learned early in life that you do things in a hurry and you will get them wrong for sure. And we don't need to get this wrong for the town and get ourselves into another large legal bill. And I'm not speaking against either the applicant or the Hamiltons. I think they've got I think Wade's done a wonderful job. I think we've got some technical stuff, as I described, that's got to get cleaned up before we vote. But I don't think we can, I can't vote for, I can say I can't vote for a plan that is in violation of the ordinance the moment we vote for it. Because all of a sudden, I think we've got a lawsuit. That's all my comments.
Tom, I see you with the microphone ready.
Boy, am I glad you're sitting up here. Explain your second point one more time for someone who is not very technically or legally oriented, which is who I am.
Well, you're talking about the exhibit map, schematic plan, and how important that is?
No, I understand that, but then it was the second point after that you were talking about, the 30-foot setback.
Yes, the 30-foot. They've got a lawsuit going on, and I'll be honest with you, neither of them, I think, describes it completely accurately, but that's just the way lawyers sometimes do things. They're arguing their side, and they see it from that perspective, and nobody's trying to do anything wrong. It's just the way lawyers sometimes think when they're advocates. I didn't get a chance to read it until today, and so the audience knows we didn't know we were going to hear this thing till about 48 hours ago. And so, to some degree, we have all been caught flat-footed. I've spent most of the last 48 hours working on this to be able to talk intelligently about it tonight. And I did not get a chance to read, and I emailed Brandon this afternoon when I finally got a lot of other things sort of cleared through in my mind, and to send me a copy of the decision. But the decision, it appears to me, the decision of the court basically kicked the Board of Adjustments decision back and made a number of findings. With respect to the setback findings that were made, basically they said that that there was not an appropriate finding of fact and description of why the facts were found the way they are. Is that correct, Brandon? But with respect to the setback, what I think they said was that the town, both the town Board of Adjustment and the town zoning administrator had ruled that because the state had classified the stream as ephemeral, the 30-foot setback automatically did not apply. And there was not any issue of discretion. And the court held no, and they didn't hear or consider any testimony that was offered by the Hamiltons opposing it being automatically classified as ephemeral and escaping the 30-foot. It seemed to me they said testimony could be offered that even though it was ephemeral, the 30-foot should still apply because of environmental concerns or other objections. And they kicked it back and said, you've got to listen to them. Is that correct?
Brandon?
Yeah, so I think that the thrust of the court's opinion was that the issue was remanded to the Board of Adjustment for a hearing de novo with instructions to consider that evidence, which the board did not consider when it first heard the matter. Now, I want to give a big caveat with that is a simplification of a very complicated order that is currently on appeal before the North Carolina Appeals, and there are attorneys in this room or listening who might have strong disagreements with my classification of that. But I'm looking at that order as the town's attorney, and that's the thing that jumps out at me. There are a lot of findings of fact in that order, and I think that the exact meaning of those findings of fact are being litigated even as we speak. And I do not want to get involved in expressing an opinion as to those findings.
But my point is, whatever those are, I don't see this approval of a zoning matter resolving that dispute as to whether that setback needs to be met in order to comply with our stormwater ordinance. And I don't think we have the power to do that. And so a condition or some clarification to whatever we approve, in my opinion, needs to make it clear that it doesn't do that, unless somebody thinks I'm off base.
Brandon?
Well, I will say that in the short time that I've known Mr. Blake, I have never known him to be wholly wrong. And he always raises good points. So this is what I would say is let's step away from this case and let's look at land use decisions generally. And when you are looking at a piece of property, again, not talking about this case, and you were talking about the strict application of a zoning ordinance to a piece of property, right? That maybe the house needs to be located in a certain area of the property apart from a line. If you want to be closer to that line, a way to do that is to apply for a variance and say, hey, there's a hardship, I want to be closer to that line. That is a quasi-judicial process that is appealed and goes through the North Carolina court system. Right. Another way, when you're looking at that parcel of property, is to say, I want to be closer to that line, is to say, well, we're going to apply for conditional zoning, and it'll be a legislative decision. And a legislative decision would, if a conditional zoning could, allow your house to be located closer to a property line. That's something that conditional zoning ordinances do. Either one of those things will allow the house to be located in a way that under a strict application of the standard zoning rules that will apply to all properties, that it will allow you to alter those rules. And they're just two different things. One's a judicial process, one's a quasi-judicial process, I'm sorry, and the other one's a legislative process. And, those just, they both can find their ways into courts, but they are just unrelated to each other. Now, it's more complicated than that here, and I'm sorry that I can't give you a simple answer to say the impact that order has on this parcel. I think there's a good argument to be made that they're just wholly separate processes, and it doesn't matter. And I think that other people could make the opposite argument. Gosh, as I hear myself talk, Marty didn't kick me, so I hope it made some amount of sense. But I understand it's complicated.
Even I understood you, Brandon.
And I'm not taking sides in this issue about whether let me make this clear. I'm not taking sides in the issue of whether that 30-foot applies or doesn't apply. I'll say it. I personally, my reading the ordinance, I initially thought that actually the town was correct. That the town administrator, or rather the zoning administrator, was correct in saying if it was ephemeral, it didn't apply. And I personally would have thought that the Board of Zoning Adjustment was correct when it supported what the town zoning administrator said. That's not what the court said. I'm just saying we don't want to get. I don't think this solves that problem personally. And just again, we're inviting getting into a lawsuit if we're not clear on just what we're doing. And I don't think what we're doing here is granting or maybe we need an application that more clearly says that what they're asking for is also a waiver of the stormwater requirement with respect to that buffer. That's not part of what they're asking. I don't know the solution. It's just, as Brandon said.
Mayor, can I make one very quick clarifying point? And Brandon can correct me if I'm wrong. But it's my understanding that if you all chose to enact the conditional zoning tonight, then you would be instructing staff then to go prepare an ordinance with the conditions listed and bring that back to you for your approval. So that's, in my experience, that's how that process worked, and I just wanted to clarify that.
That's what I understood Mason to say.
Well, this again is different because the thing that you're talking about has already been built. And, you know, in a lot of these places, you do see in a conditional zoning, a draft ordinance presented with all of the things. So, you know, I think that that is the way I imagined it as well, is that we would get some instruction from the board. This is, again, I'm going to back away from talking about this case, but you could imagine a conditional zoning approval coming from the board and saying, we want to do this. The conditions are that it must be constructed as depicted in this site plan. And there's no real conditions other than that. Or you could imagine a list of a lot longer conditions. You know, I think that it would be legally permissible for us to receive instruction from the board and come back with a draft ordinance for you to look at. I would not draft an ordinance or say we ordain orally from the dais here tonight that this is what we think. I'll say this too. A good application can make all the difference in the world. I think that it's something that the applicant can think about. Does the applicant want to take the opportunity, if this board would allow the applicant to submit some sort of application that says more? That because I believe that the first application that was submitted may have been submitted without the aid of legal counsel. I think it was handwritten, and I think it, you know, did its best to get the process started. But a good application can make easier work for a board.
Tom?
Brandon or Mason, the Board of Adjustment approved the map, the schematic of what the Burns presented. That's what we're acting on, or that's
Yes.
That's what we should be acting on. We don't have the right to countermand or change what they have already approved, do we?
Yes, we do. Actually, our conditional zoning ordinance gives us broad power. We can, if we wanted to, we could draw it up just the way we want, pass it. Everybody could make their own little change, present it to Wade, and it's take it or leave it.
Okay.
But, you know, that theoretically.
So, despite the fact that what the Burns submitted to the Board of Adjustment, that is on page 48 of our packet, does not show a driveway, a gravel driveway, or a paved driveway, that doesn't matter. We have.
It matters in that if we get back an ordinance that doesn't show a driveway here, then we would be a proposed ordinance that doesn't show a driveway, then we would be approving something that was against the law, against the ordinance the moment we approved it. And that would be very problematic. Again, unless we added a condition saying remove the driveway within 30 days.
So after all that, what's the solution for tonight? Is it to give it back to staff? Or is it can we do the site plan and take care of that and then get the rest of it to go back to staff, or what?
I don't think we can vote on any of it unless it's all together. It's really one thing, and I suggest we give it back to staff, and certainly we can invite either side here to submit its comments to staff and requests for provision in the conditions, and the staff can actually bring us back and say, here's what we recommend, here's what we believe is appropriate, and here's some other stuff that Party A wants, here's some other stuff that Party B wants. Again, this can be a fluid process as we try to bring this conclusion, this matter to a conclusion is in the best interest of the town, which is our only care here.
And do we have to state those conditions tonight for them to act on? Or
I think that the staff knows we've got, because it's in the application, staff knows we've got 6 conditions, critical elements, I think was the way, they're in the application. And then there's 16 of these preventative measures. And those are again, the housekeeping, get them in there. And then we've got the loose ends that we've identified, and some others may have others that they want to give the town staff, but we've got the swales on the adjoining land, and then we've got, make sure we've got repair, replacement, maintenance covered of the improvements, and that we've got permission for the improvements that are off the land to be there, to continue to be there, to be maintained and repaired, and some method to maintain and repair them. I know the taxpayers at Montreat don't want to maintain and repair them, but if they're in our right-of-way.
We have several that are maintained and have to be inspected by the state every year, if I'm not mistaken.
So we want to make sure that's not on our, for better or for worse, these folks don't pay taxes, and we don't need to be spending our taxpayers' money maintaining their drainage system.
Savannah, have you got a grasp on that?
Clear as mud.
Vaguely?
Mason's not
Maybe.
going anywhere, and neither is Brandon. They'll be around.
Yeah. Do you have any thoughts at this juncture? I don't think I have any.
So I'm interested in, I think Mason raises a lot of good points as far as how much nicer it would be to have an ordinance in front of us. I'm sorry, I'm not, for this board to have an ordinance in front of them that was clear and you knew what you were talking about and everyone was on the same page. I think one way to get there is a withdrawal and a resubmittal of an application. I think another way to get there is a denial tonight and with leave to withdraw. There's been some legislative changes on zoning decisions recently that I would want to keep in mind. I don't think that, I need to think about that just a second. I'm sorry. So I think that a step one might be to hear from the applicant's counsel and see if after listening to this conversation, they have any procedural thoughts. And as I say this, I want to say I'm talking about the applicant here. I am not trying to exclude any other interested people who are watching this hearing and say that they don't have a voice. But for these applications, the applicant is kind of the one in the driver's seat. So that is the reason why I'm framing these things and what the applicant is looking for here.
Step to the mic then. You or your attorney?
He'll come behind me, but there's a couple things I can help with.
We're going to need both of you?
I'll try to talk fast, Mr. Mayor.
I'm not hurrying you up. I just want to be clear that we stay on point.
Clarify something that might help Mason. The 2 catch basins that are in the right-of-way, that's right-of-way owned by MRA, and they gave permission for those to be installed. And the swale that's to that one side of the property, we created that by how we built the house and elevated the soil on our side. And where the swale exists, we created a 20-foot easement that the owner has to maintain that for future sewer. And so that won't be built on or altered or whatnot. And so that swale, but you can't require them to be out there with a shovel or anything. It's just that we had the advantage of being able to do it because we owned the property at that time. So we added more than necessary. But the 6 provisions for what I anticipated would make it easy for you to use the 6 pieces as the conditions.
Wade, the MRA gave you permission to install it, but did y'all go to any extent talking to our people about stormwater at that point?
About maintenance.
I mean, you put in those drains on MRA's property, with their permission, but did anybody apply for or talk about stormwater, where the water was going and
They
everything?
came out and looked at it.
Do we have recorded easement? Again, I know you haven't.
Because it's in the right of way. The town puts stuff in the right of way all the time. They own it, but here the MRA who owned it gave permission to do it.
I'm just asking if anybody took into consideration what you were doing with those drains and where the water was going. Was the stormwater ordinance even considered when y'all put those in?
I don't know for sure. I know that the reason we put them in was to protect the Hamiltons.
I understand, but okay, no. Yes, sir.
Yes, sir. So to address both points Mr. Blake and Mr. Freeman made, I think it would be helpful, and this has become very nuanced, so y'all are very fortunate to have a land use lawyer on the board to explain it as well as he has. I think it would be helpful to understand the direction the board's going in if you're inclined to approve or not. And your town attorney will have to advise you, but if there's not a majority of the board that's inclined to approve it, then I think you would deny it, and then we could resubmit. We could talk about that. If there is an inclination to approve it with conditions, addressing concerns that have been raised, then I think the way to go would be to come up with a draft ordinance. We'd be happy to prepare that, provide it to staff for review so that you all have a final document. If you're inclined on the second route, the question I would ask, because I think you'll make a fair point that the paved driveway is not shown on the map. The question would be if there is a correction to show that or a condition that says a paved driveway is authorized, would that be sufficient, or do we think that it's a more fundamental issue of the paving happened after the application was submitted, so it just can't be allowed? So that's the one question that came up in my mind as I heard this discussion.
Well, I can only speak for myself. I would keep an open mind with the paving, but I would also say that I would need expert, serious testimony that adding that pavement that the system worked with that change, because the only record we've had before us, other than, again, an engineer that y'all brought the last time that hadn't done any calculations. I'm just saying that works, that somebody really looked at it, really studied it, and can really tell us in an expert fashion that there's no adverse impact on water quality and water quantity than as it was originally authorized. Or if it does have that, what are you going to do to mitigate it?
Mason, but in reality, Hurricane Helene happened before that driveway was asphalted.
Right. So we can't
rely
on Hurricane Helene as proof it works.
Well, and what I was going to suggest, the board are amenable to, is you could impose a condition that says something like the asphalt driveway can be allowed to remain if you have a sealed letter from an engineer stating that they've run calculations and that it meets the appropriate standard. And I could work with Brandon and with your manager to come up with appropriate language and something to the effect of, yeah, if it can't be certified, then I'll leave that to you all. It either has to be removed or mitigation has to be, done, with engineer supervision. I mean, I think there might be a way to do something along the lines of what you're suggesting.
I think most of the commissioners probably would want to be able to hear the engineer, not just simply get a sealed letter,
Okay.
to ask questions, given that we're dealing both with water quality and quantity. I have, in the past, since we've only had 48 hours to sit with this, I wish I could give you more information than that, but we didn't, again, know we were going to be where we are 48 hours ago. So
Would it be helpful to this board to have both the calculations done and because our engineer is available tonight. I don't, in candor to the board, I don't think he's done those calculations that we're discussing. To have the calculations done and then have him here to speak with you at a future meeting.
That's a possibility, but, you know, really, if we're going to make a decision, I want an unbiased person engineering the thing. I want someone who's not being paid by you or by you, Will, to look at it and give us an opinion. That's just the way I feel. And you know, and I'm not saying we hire somebody, but we've got some engineers that do a lot of work for us right now, and perhaps they could do us a favor.
You know, Mason, you said Mason has an open mind about this, but I'm not sure I do have an open mind about the driveway because of the way it was done. I went up there the day that we were supposed to vote that night on a Thursday. It was snowing, and there was the paver out there paving it at the last minute on the day that we were supposed to vote. And I felt like that was a sneaky move. I'm sorry, but that's the way I feel about it. So I would have to have a lot of persuasion to think that that driveway should be there when I felt like it wasn't supposed to be there and it was sneaked in at the last minute in the snow. Somebody suggested that the pavement would be hardened before it ever hit the ground.
Any other commissioner? Any other comment?
I want to add one more thing. I think the Hamiltons have offered a compromise repeatedly over the last few months, and we've never addressed it. And when do we address the possible compromise to put this whole thing to rest?
Don't know the answer to that. It's up to you guys. I don't get a vote. Thank God.
Well, one of the things we can do, because it's conditional zoning, so we can decide what's fair between us, and neither of them need to be happy with it. But this, we can say, if this is going to get done, it's going to get done with these conditions. And if Wade's willing to do that, you know, what we think is fair, which may not be everything the Hamiltons want, but some of what they want. And then Wade can take it or leave it. That's the way you know, we could to some degree be mediators of this dispute. Although I think we've all spent much more time with this than we prefer to.
Well, I'll just comment that I was with Kitty on that snowy day, and I feel the same way that you do, that quite frankly, even the paper said, well, Mr. Burns said it had to be done today. That was a quote. So I don't feel real good about that process.
So I think you all have a couple of options for tonight. You can approve or deny the conditional zoning. But I think this is correct, Brandon, if they want staff to bring an ordinance back, they do need to approve the conditional zoning and then have us bring it back? Or can we continue it and bring it back at another meeting? Is that okay?
I think that would be okay.
So that would be another option, would be to continue this public hearing again to a date certain. Let us get a proposed ordinance together that lays out the conditions and then consider it with the ordinance at another time.
Staff and our attorney will draft the ordinance.
I think Mr. Morphus has offered to draft an ordinance, but we can work on who does the drafting.
I have nothing against you, but again, I would rather our staff and our attorneys work on the ordinance rather than one side or the other before preparing an ordinance. That's just my personal belief. I want to stay as unbiased as we possibly can and make a just decision that will. I'm not Solomon, neither is this council. We can't cut the baby in half or propose that. But I want to be fair with everyone, okay? As fair as possible.
And we really want to be fair to the conditional zoning that we have in our statutes here. So, you know, it's very important that we do the right thing and that we have all the information.
We're going to approve or deny?
Move to continue.
Continue. Got a motion to continue? Got a second? All in favor signify by saying aye.
Aye. Let's set a date.
Yeah.
Let's set a date.
It's not going to be May, it doesn't look like.
No,
Unless it's going to be a
I
special
think
meeting.
June or July feel more realistic to me anyway. July. Okay.
4th of July.
So that would be, so you all would be continuing it to the regular meeting on July 9th, 2026.
July 9th it is. That's the proposal. All those in favor signify by saying aye.
Aye.
Opposed?
Oof, we're not through. We're just now getting started.
Anyone would like to leave, go ahead.
It's new business.
No, you got to stay. Okay, new business. Folks, we're still conducting business up here. Folks, we're conducting business. Thank you. Under new business, item A, ordinance authorizing the limited use of golf carts.
Yes, sir. So you'll all remember last year you all approved an ordinance allowing the limited use of golf carts for the 2025 Worship and Music Conference. The MRA and the Presbyterian Association of Musicians, I think that's correct, are asking, yes, she's here if you have any questions about this, but they're asking for limited use of golf carts again this year for the Worship and Music Conference. I see no issue with it. I think that it went well last year. There were no issues, and our police department was able to manage flow of traffic and everything just fine. So I'll leave it to your discussion, but that is the proposal.
I, as well as the Hamiltons, were down at the Nature Center during that time when they were using those golf carts last year, and I saw no problem at all.
I do have a question. When is Pam over? Is it over the 3rd or the 4th? The 3rd. 3rd. So that you really want it to be, the golf carts won't be needed, or won't be used on the 4th? Not at all. Perfect.
Do I have a motion?
So moved.
I have a motion to approve. Do I have a second?
A second.
I have a second from Commissioner Dasher and Prancer. All those in favor of the motion to approve signify by saying aye.
Aye.
Item B, opposed? No opposed. Ayes carry. Resolution authorizing the town manager of Montreat to execute an amended joint cooperation agreement to add the town of Mars Hill and the town of Marshall to the Asheville Regional Housing Consortium.
Yes, so this is just a minor housekeeping item. We are members of the Asheville Regional Housing Consortium. I attend those meetings when I can. The town of Mars Hill and the town of Marshall would like to join the housing consortium, but to do so, all of the members of the consortium have to vote on allowing them to enter. So that's all this does, would be approving Mars Hill and the town of Marshall to be in the Asheville Regional Housing Consortium.
Do I have a motion?
I'll move to approve.
I have a motion to approve from Mayor Pro Tem Fouché, second.
Second.
Second from Commissioner Widmer. Discussion. All those in favor of the motion signify by saying aye.
Aye.
Opposed? Ayes carry. Let's see, we got item D, but I'm going to go out of order and skip the closed session. We'll come right back to it. But Savannah, you want to talk about the amendments to the budget?
Yes, so we have two budget amendments for your consideration. Budget Amendment 13 is to move funds from our streets department, the capital outlay line, to sanitation capital outlay to complete the convenience center upgrades to the gate that we discussed at our last budget meeting. You all instructed us to try to find that money in this fiscal year so that we could make those